Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to another episode of our Curious Amalgam, the official podcast of the American Bar Association's section of Antitrust Law. I'm Matt Reynolds. In today's episode, we ask the question, is the EU bringing big tech to heel? Compliance Day under the EU Digital Markets Act. Like most other aspects of daily life today, the practice of law is increasingly mediated and influenced by technology. The recent pandemic brought with it virtual client meetings and remote depositions and tied us even more tightly to our computers and smartphones. And for those of us who can remember the heyday of competing internet browsers, BlackBerries, and flip phones, it seems like the number of companies whose technologies we use is shrinking every year. With this kind of consolidation comes a status as a technological gatekeeper, and questions about what such gatekeepers should and shouldn't be able to do with their products and the products of their competitors. Today, we explore the approach the European Union has taken in prescribing those do's and don'ts in its Digital Markets Act, and how tech giants have gone about trying to comply with it. Joining me today to introduce our guest and lead our conversation on this interesting topic is my co-host and former colleague, Matthew Hall. Matthew?
Hi, Matt. Thank you. Our guest today is Aleksandra Zuchowska. Aleksandra is Competition Policy Manager at CCIA in Brussels, the Computer and Communications Industry Association. Her focus is on competition in digital markets and online platforms, including the application of the EU Digital Markets Act, or DMA, which you referenced. Aleksandra appears today in her personal capacity, and therefore her views are her own and do not necessarily reflect those of the CCIA or its members. Hello, Aleksandra, and welcome to the show.
Hi, thank you so much for having me here today.
Well, thank you for coming on. By way of introduction, the EU Digital Markets Act, or DMA, introduces a radical change to enforcement and regulation of the digital sector in the EU. It establishes a set of criteria to identify gatekeepers, which under the Act are large digital platforms providing so-called core platform services, such as online search engines, app stores, messenger services, and others. In relation to their operations in the EU, gatekeepers have to comply with a long list of do's and don'ts, which will impact the functioning of these core platform services. This is therefore ex ante regulation. The DMA complements but does not change EU competition rules, which continue to apply in full in the EU. There are currently 6 gatekeepers and 22 core platform services. The gatekeepers are the names everyone will, of course, recognize: Meta, Alphabet, Amazon, Apple, ByteDance, and Microsoft. And the CPSs, or core platform services, include, amongst others, Facebook, Amazon Marketplace, WhatsApp, and YouTube. So it's interesting to note, in passing perhaps, that 5 of the gatekeepers are US-based companies and 1 is Chinese. None are EU-based or originated companies. The DMA entered into force in November 2022 and became applicable on 2 May 2023. 7 March 2024 was Compliance Day, when the 6 gatekeepers had to start complying with the practical obligations under the DMA. So, Aleksandra, as mentioned, the DMA establishes ex ante obligations for gatekeepers, these do's and don'ts. What is the underlying principle and the basic idea behind these obligations?
So I just want to say that was a great introduction to what the DMA is. And about your question. So the whole idea of the DMA is to bring more contestability to Europe's digital markets for rivals of the biggest companies, the so-called gatekeepers, as you explained, as well as fairness for the business users of those gatekeepers. And indeed, the obligations and prohibitions are at the core of the DMA. And here also what you're mentioning, this relationship between the DMA and competition law. something interesting to maybe underline at this point of introduction is that some of the obligations and prohibitions of the DMA, they actually stem from past or ongoing antitrust cases in the EU. And to give an example, for example, a prohibition of self-preferencing in ranking, indexing, and crawling that we have in the DMA stems from the Google Shopping case in the EU.
Yes, and the European Commission likes to say that the DMA, quote, creates a range of new opportunities and rights for businesses in the EU. And of course, obligations and prohibitions on the other side, on the side of the gatekeepers. So in a bit more detail, who is this important to, apart from obviously the gatekeepers, and why?
Simply said, to everyone. But yes, to go into more details. So indeed, first of all, gatekeepers, the biggest one, the addressees of the DMA, who had to really dramatically change their business models, products and services to comply with the DMA. Secondly, important to business users and access seekers, because they are the ones that are gaining something from the DMA. And by gaining, I mean, for example, more access to data. And thirdly, to consumers. And this is the element which is actually very often forgotten in the whole DMA debate and the impact the DMA has. So as said, a lot of products and services that we use every day have now changed. And the question is now, did it change for better or for worse? And that's here what's important to stress is that there are certain trade-offs to the DMA. So in some instances, the DMA prohibits practices which were often found in the past as pro-competitive ones. And when we prohibit this kind of practices, there might be some negative consequences for the market, innovation, and for consumers. So what I'm talking about here is, for example, companies having less incentives to innovate, which could result going further in less consumer choice or less diversified products on the market. Or simply said, Europeans might be missing out on some digital offerings that will remain available to consumers in other territories. And that could be the result of the DMA being in place here in Europe.
Indeed. I think we'll get onto some of those topics in a bit more detail. But as you say, there are various consequences. It may be, for example, that consumers in the EU no longer see some types of services which they've, or at least quotes, bundled services, which they've been used to using and enjoying in the past. Maybe you could identify a specific do requirement under the DMA and give us another example in practice of what exactly this is trying to deal with.
Yeah, so I think maybe something quite easily understandable, because many of the DMA provisions, they are written in a way that are quite difficult to translate to someone who did not spend last 3 years following the legislative process. So perhaps one of the articles which says that the gatekeeper shall allow and technically enable end users to easily uninstall any software applications on the operating system of the gatekeeper. So what it means is that now that we have the DMA in force and after the compliance deadline, we should be able to uninstall software applications on the devices operating on an operating system, which obviously was designated as the core platform service under the DMA. So the rules of the DMA apply to this service. And the objective of the legislator here, as it is written in the DMA, the recitals of the DMA, is that this provision should increase users' incentives to obtain and use services of third parties. So again, we come back here to this contestability being one of the aims of the DMA.
So I think this is Article 6.3 of the DMA. And an
Exactly.
example would be what? Something like deleting a weather app from a phone, something like that.
Yes. Being able exactly to remove an application from the operating system.
Provided, of course, as a gatekeeper and it's a CPS service. All right. Well, let's look at one of the don'ts. What is a good example of a don't and what it's trying to deal with there?
So here there is one example that I usually use because I think it's quite easy to imagine. So I'm talking here about Article 5.3, which prohibits wide and narrow parity clauses. So what this article does is that it prohibits the gatekeeper from preventing its business users from offering the same products or services to end users through third-party online intermediation services or through their own direct sales, online sales channels at prices or conditions that are different from those offered through the online intermediation services of the gatekeeper. And the objective here again of the legislator was to foster inter-platform contestability, to ensure free choice of alternative intermediation services, and allow multi-homing. And in practice, to explain what it means. So, for example, let's say I am a hotel owner and I'm using some big booking online platform to promote and sell rooms in my hotel for a price of, let's say, 50 euros a night. Let's make it not too expensive. And now, now that the DMA applies, as a hotel owner, I can obviously continue doing this. But at the same time, I can offer and sell rooms at my hotel at other booking platforms, as well as at my own hotel website for cheaper price. Or I can offer some special discounts, which I did not offer or do not offer at the initial big booking platform I've been using. But this is, of course, only when this big booking platform that we talk about here is designated as a so-called core platform service under the DMA. So as a result of this, as a hotel owner, I can continue using this one big booking website to promote and sell rooms at my hotel, benefiting from the fact that this website has a lot of customers and my hotel may easily get noticed by potential customers. But by offering rooms at my hotel at a cheaper price at my own hotel website, for example, I can get the actual bookings done through my own website, which ultimately saves me paying the commission to this big booking website that I use. So I hope this explains it well.
Yeah, that's a very useful and practical example. These are MFN type provisions, which have been looked at a lot under competition law in the EU and elsewhere. Is, of course, a very controversial piece of legislation, or was during the process. You mentioned already concerns about consumer choice, availability in the EU, and some features may not possibly being available or not being introduced in the EU. What about potential consequences, for example, on innovation?
So I think it's also connected to what I've been saying before, that having those rules in place now in Europe, some companies might be disincentivized to invest in Europe, to bring more products, to bring more innovation. This, of course, to the detriment of the market and of consumers in Europe. Then what I was saying before also about those pro-competitive contacts being prohibited, resulting in the fact that companies, again, do not really want to create any product upgrades or do not want to, but might have less incentives to bring new products or product upgrades in the European market. So overall, there is a risk that it will negatively impact innovation. Obviously, this is to be monitored, but the concern is there.
And what about companies, for example, just saying, look, I'm not going to bother to innovate myself. I'm just going to kind of become a remedy taker here. I'm just going to use my rights under the DMA and I'm just going to kind of piggyback on the platforms that way.
Yeah, absolutely. And I think this is a valid concern, and this is something that would go directly opposite against this contestability objective of the DMA, right? The contestability was not supposed to mean this. It was not supposed to stifle innovation.
Similar to that, I mean, one of our guests on our Curious Amalgam podcast pointed out that the DMA is not going to really add any points to EU GDP. That's kind of a comment about industrial policy in the EU. Do you have any thoughts on the relationship between this and general industrial policy?
Yes, so as you mentioned in your introductory remarks, we have now 6 companies designated as gatekeepers, right? And 5 of those are originally American ones, and there is 1 Chinese. And that's the situation right now. This might change in the near future. Maybe we'll have some European gatekeeper, but focusing on what there is now and taking that into account, one could speculate that rather than promoting competition, the DMA could end up distorting competition between companies which are in and out of DMA scope. And we see that many companies offer very similar products and services, and it's not always clear why some are in the scope and others are not. So this is also the discussion that has been growing here in Brussels, and something to be monitored.
A bit like there, the European Commission, as the main enforcer of the DMA, could become a kind of gatekeeper itself over who's in and who's out.
Exactly. Right. That's the concern that is there. And I think that's something that you would not want.
And could we talk a little bit about what the process would look like for other companies to be designated as gatekeepers, or for additional services or softwares to be designated as core platform services? I can say for myself as a litigator, I think about, circumstances where one company might want to lobby affirmatively for a competitor's product to be designated as a core platform service, because I know that will entail obligations on this competitor that might inure to my benefit as competing with it.
Yeah, I mean, there are set thresholds in the DMA, right, for the service and for the company to be meeting in order to be possibly designated. But I think the one more thing, one more trend that I have personally observed is that when there is a product or a type of product which comes out to the market and starts to revolutionize the market. And what I'm talking about here is, for example, generative AI. This is something that starts to pop up in the heads of the legislators and regulators that, okay, then if it's something that is big and will be bigger, then automatically we try to consider how it fits with the DMA or if something should be done with that.
Looking at another controversial issue under the DMA, often discussed, is safety and privacy. Some companies have suggested that, for example, the side loading and alternative app store obligations under the DMA are dangerous, or at least risky, introduce more risk. And I actually noticed which was flagged on one of the CCIA blogs, that in September 2023, which seems extraordinarily late, really, the European Commission asked for tenders to look into security issues around the DMA. So what's your thoughts, and what are your thoughts about these security issues and safety issues, and whether they're really being properly taken into account?
So this is another element in the discussion about the trade-offs connected to the DMA. I think everyone here in Brussels, probably beyond, agrees that the DMA shouldn't be used to degrade users' security and privacy, right? But in practice, that's probably a different story to what we're observing. So, for example, we should think if a search engine, just to use some maybe practical example, a search engine which is known for low or none level of security and safety, be one of the search engines presented to EU users next time they open their web browser, and be placed next to search engines which we can say ensure security and safety of their users. In theory, sure, that would increase contestability about the DMA, but is it also desirable? Is it really desirable from the security point of view? That's something that should, those kind of considerations should be there. And such trade-offs should be monitored closely just to ensure that the DMA doesn't become exploited to the detriment of consumers, companies, governments, and their safety.
Yeah, and that example, I mean, there are various search engines out there, which we don't need to name, but they're not necessarily going to be EU-based. So again, it's not necessarily going to benefit an EU company at all. But at the same time, it could negatively or even dangerously potentially denigrate the EU citizens' use of the search function.
Yeah, I think it just shows that not everything is so black and white, and the per se rules do have trade-offs, yes, as we talk about, which should be taken into account by the enforcer.
Yes. So moving on from those topics, and we're now in the compliance phase, as I mentioned in the introduction. Compliance Day under the EU DMA has now come and gone in March 2024. The gatekeepers had to submit compliance reports to the European Commission. It's up to the gatekeepers to sort out their own compliance plans. Some of these, I know they range in size, but some of these were vast documents. And for example, Meta commented that it's committed an almost unprecedented level of resources to delivering its compliance. Over 11,000 employees worked on it, with more than 590,000 hours of engineering work and a well-dedicated and well-resourced compliance function just to deal with the DMA. So clearly quite an extraordinary amount of work for that one gatekeeper. So firstly, looking at how the Commission should be considering compliance. As we mentioned, it's up to the gatekeepers to do it themselves. So there seem to be a number of ways of sorting out their requirements.
Yeah, so start with, I like what you underlined here, the amount of resources and time that went and goes probably every day into compliance, because I think it's something that we as a public are generally not aware of. And I think it shows how seriously those companies are taking compliance, and that it's not so easy. As said before, the compliance with the DMA required really big changes to business models and to products and services. So it's also not something that happens in one day, and the compliance, it did not start or end with the 7th of March, right? But speaking about the assessment of the compliance, so something that now that we are past 7 March deadline is happening, I think here there are 4 key points. First, companies meaning gatekeepers, should not be all required to implement the same compliance solutions when they are meaning in relation to the same obligation and same type of service. Why is that? Well, their business models differ, right? So it seems only natural that the compliance solutions also differ. Second thing, the compliance solutions, when being assessed, should be confronted against not only DMA's objectives of contestability and fairness, but a broader policy and regulatory context, I think, should be taken into account. So what it means? This means that the impact of those compliance solutions of gatekeepers on, for example, fundamental rights, or how they interplay with other EU legislation, like GDPR, should be taken into account when assessing whether those solutions are compliant or not with the DMA. The third thing I'd say would be that the DMA compliance assessment should take into account industry realities and capabilities. So here linking to what we both said at the beginning, right, about the resources that go into compliance. And fourthly, and lastly, and also I think it's the most important point, is that I think there should be no casual links between the DMA compliance measure and its impact or lack on the market. No kind of this casual link should be established. So why do I say that? So taking a step back, we need to remember that digital markets are dynamic and are driven by disruptive innovation and various external factors. which are often beyond the control of gatekeeper designated companies. And that's why gatekeepers cannot and should not be held accountable for the lack of, for example, entry of new market players. This, as I said, external factors which are unrelated to gatekeepers' compliance measures may influence such entry or lack of such entry. And here, for example, companies may seek to expand their operations based on strategic considerations, such as forging new partnerships or responding to consumer demand. And that's why they decide to enter or not the market. Nothing really DMA related, right? And similarly, the assessment of the DMA's effectiveness should not be contingent upon whether business and end users of gatekeepers actively make use of the benefits provided by the DMA. Because such decisions are ultimately driven by personal or business considerations, influenced again by many factors, not necessarily DMA related. And having said all that, I think the conclusion is that the effectiveness of the DMA's compliance should not be defined by the market effects or lack of those market effects, as in the end, the DMA itself does not anticipate such casualty.
Yeah, that's a very interesting comment. Your last point there, number 4. I think one of the gatekeepers at one of the workshops we'll discuss in a minute commented that what will be made available is exactly what the law requires. So we'll comply and then we'll see what happens in the market. But do you think here Article 8.1 of the DMA is at all relevant, where it says that the measures to ensure compliance shall be effective in achieving the objectives of this regulation? Or is that simply reflecting, look, you're required to comply, but not necessarily responsible for what happens in reality in the marketplace?
I think the word effective is key here. And I think that the DMA does not really have a definition of that. But in my view, the DMA is about creating opportunities, not about creating market effects. So I'd say the latter that you mentioned. I understand it more as a legal compliance. We comply with what is in the law, and how end users or business users, how they react. That's a different thing, because as mentioned, there can be multiple factors that influence decisions of an end user to download, let's say, an alternative app store, right? The key is that they are able to do so, that the opportunities are there.
Yeah, so it shouldn't be dictating outcomes. Personally, for what it's worth, I don't intend to download a potentially unreliable app store onto my phone anytime soon. So what is the state of play on compliance and the next steps for the Commission here?
So on 25th March, I think, yes, you probably also heard about it, as it was, very big news, right? The Commission launched non-compliance proceedings against some of the gatekeepers and in relation to some of the obligations. And it came in an interesting time, because it was, days after the compliance deadline, right? Not even a month passed. And also it was before all of the DMA compliance workshops, so the events where each of the gatekeeper was invited by the Commission to explain to everyone who's interested their compliance measures. It was before all of those DMA workshops were done. And why it matters, I will say in a moment. But so that was the timing. And so launching those non-compliance proceedings now, for me, questions the idea of companies and Commission working together to implement the DMA successfully. What we've been hearing, that there's a lot of work, there's a lot of dialogue, and I'm not saying that's not happening. I'm also not really, I'm also not part of those conversations or in the room to say that it's there, but that's what we've been hearing. But then, so we have this technical level, but on the political level, launching those those non-compliance proceedings now, and saying, okay, we have a suspicion there's non-compliance, it's again something paradoxal here, right? So there are two levels here, what's happening on the technical level and what happens on the political level. So it all makes us wonder, whether the compliance process might be politicized. And one more thing I think worth mentioning is that during those DMA compliance workshops, Commission officials were stressing the need to see and study data on the impact of the DMA. And as we all know, gathering data takes time, right? But what we see now, however, sends worrying signal that the EU might rush into investigations without really knowing what they are investigating. And this kind of approach should be concerning to really everyone. So it's, those are really interesting things happening right now. And I'm very curious to see, what's going to happen next.
As you say, maybe you can make a couple of comments, please, on the compliance workshop in a moment. But as you say, there are informal talks going on for a very long time with the Commission, even prior to Compliance Day. And it seems inconsistent for this working together concept suddenly to result in formal non-compliance investigations even before the workshops had even finished. But it also shows it can be very fast moving. I mean, do you think that potentially it is politicized, but the Commission is also concerned that it's been criticized for some of these competition law investigations taking so long that it feels it needs to just show that this is part of the reason is it just needs to show this is going to be different.
I mean, so here I would say the counter argument is that the non-compliance proceedings, they need to be closed now within 12 months. So by March 2025, we should have an answer if there is compliance or not in relation to this conduct, to the compliance solutions under investigation. But for me, it's just the timing of opening those proceedings that is just doesn't make sense. Let's maybe give some time or at least let's finish all of the workshops, right? To assess whether there's non-compliance or not.
Maybe they're just trying to pressure, or maybe there's part of their quotes negotiation that they may drop some of these compliance investigations. The companies, they've already backed down on some of these changes, haven't they? Even with social media comments from the Commission forcing effectively some of these changes. So maybe it's just kind of trying to step that up, and they're assuming that the companies are going to back down well before the end of the 12 months.
Perhaps, but here then again, we're coming back to the suspicion of politicization, right? So yeah, I don't think we will know the answer, but it's just there are a lot of questions.
I wanted to follow up on a point sort of related to this. Obviously, it sounds like we're not going to, have an answer on the Commission's view on compliance on all these points for the next year or so. But if we do eventually get to a point where these gatekeepers are, as far as the Commission is concerned, compliant with the DMA, it does make me wonder whether or not the DMA will, as a practical matter, going forward, potentially provide cover to these companies with respect to potential claims by competitors with regard to, for example, abuse of dominant market positions. I know we've talked about before the fact that the DMA is not intended to replace any aspect of European competition law, but I do wonder, as I said, as a practical matter, if by being able to show that they are compliant at some future point with the requirements of the DMA, and given the extensive do's and don'ts that it entails, do you think that will potentially provide cover to these gatekeepers and perhaps insulate them from future claims of anti-competitive conduct?
Yes and no, because the opposite consideration, I remember I asked a few times when I had an opportunity, the Commission, whether the obligations from the DMA will be treated as a benchmark in antitrust cases. And the answer was yes. So if non-compliance with the DMA would be there, it would be probably treated right away in an antitrust case, similar, I guess, as a proof of abuse of dominance. So I think there will be some interplay for sure, but to be seen, really.
Aleksandra, we've referred to the compliance workshops that went on in March 2024 in Brussels with the 6 gatekeepers, where they presented their proposals. You attended, I know, in a hot room with a lot of other people for many days. What were your impressions and comments on those?
So I think, putting aside those non-compliance proceedings that they were launched and when they were launched, I think the workshops itself were a really good example of collaborative approach and open dialogue between gatekeepers, commission, and all of the interested stakeholders about compliance, how it should look like, how it should not look like. So this is something I really liked. But I think what was very prominent is that there is still a lot that is unclear when it comes to compliance. So, for example, how the DMA interplays with other EU regulations like GDPR. There is indeed no one-size-fits-all approach to compliance solutions, that we cannot expect that. Another thing which was very prominent at one of the workshops was that different sectors and groups of access seekers expressed diametrically opposed requests when it comes to compliance solutions, and that won't be easily solved, and that there needs to be a way to balance it all somehow, because it's just not. I don't know if it's possible for everyone to work as different access seekers, different companies, business users have different interests, right? And it might be difficult for a platform to meet them all. And the last thing I think is that this dialogue between all the stakeholders and the compliance should continue beyond those workshops.
Having attended these workshops, I did want to follow up for the benefit of our US-based listeners. In listening to how these gatekeepers have approached compliance with the DMA, did you hear or see suggestions that there would be potentially benefits to US-based consumers of these products and services? Or was your sense that the solutions worked out by the gatekeepers really were EU-specific solutions that would not necessarily have any effect outside of the EU, or, for example, to users based in the United States?
Well, I think that there was just focus on EU consumers, as that's all everyone was interested in, right?
Of course.
Here. Well,
Yeah, I guess the question, as you say, is will these potentially be rolled out on a wider than EU basis? Not known. Sandra, before we finish our substantive discussion here, do you want to give us any takeaways, high-level takeaways on the DMA generally, for people just to keep in mind as we move forward?
yeah. So I think in essence, what's important, what's also interesting for me, that when we think of more contestability and fairness in digital markets, we should also think on the impact on consumers and their product experience, as well as the impact on Europe's economy as a whole. And we'll have to see if and how the DMA incentivize investment in Europe and the rollout of the new products.
Thanks you so much for joining us today, Aleksandra. It's been a fascinating conversation. We typically wrap up our episodes of our Curious Amalgam with a couple of questions that veer into more personal territory to help get to know you a little bit. So I'm going to ask you a couple of those right now. The first one that we typically ask is to tell us something about yourself that maybe even your own coworkers don't know about you.
I think my colleagues, they don't know probably that I really enjoy baking. But now that makes me think that actually that's really sad that they don't know about it, and maybe I should bake something and bring to the office.
Do you have any particular special recipes or baked goods that you love making in particular?
Yes, I think my signature dessert is tiramisu and a cheesecake. So I think I should bring some to the office.
I think your coworkers would very much appreciate that. Well, we like to conclude each episode with a segment that we call the Curious Hat.
And now it's time for the Curious Hat.
So, Aleksandra, your Curious Hat question for today is, when you were a young child, what did you want to be when you grew up?
Oh, I wanted to be to work as a vet to cure animals. And when I was, I think, 3 or 4, I noticed there was some bird that was run by a car. And I went outside and I wanted to make a surgery with whatever items I had. So that was my dream. And I still love animals, but I ended up as a lawyer. That's trying to get now a horse.
As did we all. Well, thank you again, Aleksandra, for joining us today. And thanks to you all for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.